Realize.
Senator Sears, we're live. Did you want me to run things?
Yes, please. I'm hearing an awful lot of noise in the background. Is there
Might be
something
from
going on?
It's right outside.
Oh, okay.
Ben's on it.
Ben's on. Yes, Ben's on it.
Okay. Well, they didn't invite us to the party, so. Go ahead, Senator Hashim, please.
Good, thank you. So, good morning. It's March 12th. We're starting with S-150, and our first witness is Legislative Counsel. We'll talk about an amendment.
Yes. Good morning, everyone. Can you hear me?
Yes.
Terrific. So, Maria Royal from Legislative Counsel. And at the chair's request, I have prepared a strike-all amendment to S-150. I believe it's posted on the committee's webpage under my name, and I can also share the screen and pull up the document if that's helpful, whatever you prefer.
Sure, if it's on the screen, it can't hurt.
Okay, great. Okay, so because it's a strike all and I didn't show one of the sections that was removed, I just wanted to provide a little bit of a summary at the top of the document. So this just summarizes the changes to the bills introduced. So for example, what was section 1 in the bill as introduced, that was the section that increased the statutory minimums for uninsured and underinsured motorist coverage. I believe based on your committee discussion, you agreed to not include that proposal in your revised amendment. So that provision is no longer in amendment. There are some additional revisions related specifically to underinsured motorist coverage, which I will review with you. And then also just some updates to the effective date application section. So that being said, we'll deal with section 1 first, and specifically with respect to the underinsured motorist provisions in law. You'll see that there are changes to existing laws. So these are new provisions. They weren't in the bill as introduced. And they're meant to clarify when underinsured motorist coverage kicks in, essentially. So for example, on line 16, or actually I'll just start with the lead-in language on line 14. A motor vehicle is underinsured to the extent that the liability insurance limits applicable at the time of the crash are less than the damages that a person injured pursuant to this section is legally entitled to recover because of injury or death. So in this instance, it would be the liability insurance of the at-fault driver is not enough to fully cover the person who is then carrying underinsurance coverage. So a similar proposal is reflected in subdivision 2, which specifies that the available liability insurance has been reduced by payments to others injured in the crash to an amount less than the damages that a person insured pursuant to this section is legally entitled to recover because of injury or death. So again, not enough coverage available from the at-fault driver. And then also within that section, this subsection H is identical to the provision that was in the bill introduced, and it specifies that payments made to an injured party under the liability insurance policy of the person legally responsible for the damage or personal injury shall not be deducted from the underinsured motorist coverage otherwise available to the injured party. And so I think you heard already an explanation and why this proposal is being put forward.
Mhm.
Section 2, no changes.
Are there any questions on
Oh.
section? I have a couple of, I want to
Sure.
make sure I clearly understand it. If we take the example of the gentleman who came in to testify and was involved in a crash, and in that case, his insurance would kick in because the underinsured motorist who caused the crash didn't have enough to cover the costs of his medical care. So whatever is his limits would kick in, even though his cost was several $1,000,000. This would allow him to collect the 250. I think he had 250,000 coverage.
Well, that's right, up to the limits of whatever the,
So he, in effect, would receive both the amount that he's covered for, the 250,000, let's say, and the 100,000 that the underinsured motorist was covered,
that's correct.
for a total of 350, even though the cost of the medical care was much higher.
That's correct.
Okay.
Yeah.
All
Yeah,
right, that's-
there's no deduction. So whatever the at-fault driver's liability policy was, whatever payments were made under that liability policy, which weren't enough to fully cover his damages, could not be deducted from what he is then able to collect under his own underinsurance policy.
Senator Norton.
Yes, Maria, hi. Going back to page 1, line 16. Are we just, I guess I'm a little confused with this, where it says the liability insurance limits applicable at the time of the crash are less than damages that a person insured pursuant to this section is legally entitled to because of injury or death. Well, if most folks have like a $50,000 policy coverage, they're always going to be underinsured. Is this just a definition? Is that what we're looking at here, Maria? Or?
This is just a definition.
Definition, okay.
Yep.
Thank you. That clears that up.
And
Thank you.
it is, I'm going to be perfectly candid with you. The existing law, again, under the definition, trying to explain when underinsurance coverage kicks in, that stricken language, I'm actually not sure why it was written like that. There may be a reason. I'm not, I fully admit I'm not enough of an expert in the industry, but it was a little unclear to me, just the existing law. And I think this does clarify, that your underinsurance coverage kicks in when there isn't enough coverage from the at-fault driver.
Yeah, I found 1 and 2 to be confusing also, so.
Yeah, so, I'm sure folks in the industry or in the regulatory world can, jump in if there's another technical reason that I just don't understand. But I was a little confused by the definition under existing law. So
Thank you.
almost as a layperson, this seems to make a little more sense to me, and it also is consistent with how other states define underinsurance coverage. So, are there any other questions in section 1?
Not seeing any in the room.
So again, no changes to which reflects what was in the bills introduced. So this is the provision. I'll just read it starting on line 12. However, the right of subrogation against any third party shall not exist or be claimed in favor of the insurer who has paid or reimbursed to or for the benefit of the insured medical costs payable pursuant to medical payments coverage. So this is basically saying that if an insured opts to buy medical payments coverage, which is usually coverage between $5,000 and $10,000 that's available immediately after an accident to cover expenses that arise before any kind of claim can be filed and maybe reimbursed by an at-fault driver. What this is saying that the insurance company cannot seek reimbursement for those covered expenses. In other words, it's insurance that the insured pays for and is entitled to not have to pay that money back to the insurer. I don't think I said that in the most elegant way. I apologize for that, but yeah, if you want me to clarify that further, or if that didn't, maybe it makes sense to you from your initial presentation of the bill.
I've seen any questions.
Well, I think what it does is allows the insurance company to reclaim any losses.
No, so I think I know, so this originally was a proposal from the Vermont Association for Justice, and they are available to speak to it. In practice, I think part of what is being addressed here is where if there is coverage, if there are expenses, medical expenses paid to the insured by his or her insurance company, and then later there's a settlement and additional monies are collected for the benefit of the insurer, that the insurance company cannot take from that money, cannot seek reimbursement for the coverage they've already provided to their own insured. Right? So that was the concern, is taking away potential coverage for costs that the insurer has already paid for under their policy, and not wanting that to happen. So, but again, I will defer to the proponents who can probably explain it in practice, why they're seeking this provision.
Okay. I think we need some explanation.
Yep, okay. And then section 3 is the bills introduced was effective on passage, but applied to all policies offered or renewed. Now it says offered, issued, or renewed on or after July 1st, 2024 instead of 2023.
Okay.
And so that's all I have on my end, unless there are additional questions for me.
Not seeing any in the room.
Okay, and would you like me to leave the document up on your screen, or?
I don't think that's necessary, but thank you. I think
Okay.
I think maybe we'll hear from Senator Sears had mentioned wanting to hear from the Vermont Association of Justice, or maybe the proponents, and if they're on, maybe we can get some further clarity on their thoughts on section 2.
Good morning. I'm happy to speak if that would be helpful. My name is Kristen Ross. Can you hear me okay?
Yep.
Great. So I am Kristen Ross. I'm the upcoming president. I'm the current vice president of the Vermont Association for Justice. And so MedPay coverage, just to clarify something Maria said, MedPay is a very small amount of money that is available under most insurance policies. It's usually between $1,000 and $5,000. And it's specifically only for the purposes of medical bills. Practically what happens is most people now have high deductible health insurance plans. And so if you go to the hospital and you're receiving medical care, a lot of times folks are getting a big bill for that first $5,000 worth of medical care. And the good thing is they've paid for, as part of their premiums, this coverage called MedPay coverage under their auto policies, which we can use to help cover those out-of-pocket medical bills. The thing is in Vermont, if you use your MedPay coverage, you then have to turn around and pay it back to the insurance company. So the question is, what is the point of paying for MedPay coverage that if you use it, you're penalized for it? In New Hampshire, for example, MedPay coverage, you don't have to pay that back. You've already paid your premiums. You use that to help cover out-of-pocket medical costs, and it's a part of a benefit that you get. We're just asking that Vermont remove the reimbursement or subrogation right that insurance companies have, so that when insured Vermonters pay for this money, get the money to help cover a small amount of out-of-pocket medical costs, they then get to keep the benefit of that. And so they don't have to repay that to the insurance company. That's what we're hoping to do with this provision specifically to MedPay coverage. It's a very small amount of coverage.
That's section 2.
Yes, Senator Sears.
If I can ask a quick clarification, I thought the subrogation applies to a third party and not necessarily the injured party. Can you just re-clarify that for me,
Sure.
please?
Yeah, practically it's both, right? And so what happens is, so Con Dinsmore, Senator Sears, was my client who came and testified. He was the gentleman who was hurt in the collision with the drunk driver. So just practically speaking, if Con were to receive $5,000 from Progressive for MedPay, okay? And then down the road, gets a recovery from the drunk driver from Vermont Mutual, let's just say, for example, okay? Vermont Mutual seeks reimbursement of that. Progressive seeks reimbursement of that $5,000 that Con got from Vermont Mutual, but practically it's coming out of Con's money. And so even though you're right, Progressive might be asking Vermont Mutual for it, they also can ask the insured driver though. So we as attorneys representing these folks, we get sent lien notices from insurance companies saying, hey, remember that MedPay, that couple grand we paid for medical expenses? We want that back. We're just saying, no, the client paid for that coverage, use that coverage for medical bills. Even if there's a recovery, they should be able to get that. That's part of what they paid for under their policy. Does that make sense? So it can be, the right of subrogation can be against the insured or against the other insurance company. It works both ways.
Thank you.
You're welcome.
Not seeing any other questions in the room. Senator Sears, did you want to hear from, I think we have Chris Maley on the list as well.
If Chris would like to, and if Jamie Feenan is available and he's in the room, we can certainly hear from him.
We do have Jamie in the room.
If he'd like to testify or comment.
Well, this would be great. Thank you, Senator.
Yeah, feel free to take a seat.
Do it now? Okay. Good morning, Jamie Feenan with Primer, Piper, Eggleston, and Kramer. This morning on behalf of the American Property Casualty Insurance Association and State Farm. Thanks for the chance to come back in. Just a couple of quick comments, and I understand there may be a potential vote, but just saw the revised language in I think what was termed clarifying in the definitions for underinsured motorist coverage, and I've sent that out to folks, but haven't had a chance back to see if in fact we agree that it would be clarifying. So whether that's a determining factor in your schedule, sometimes this is a confusing area of statute, and just looking for the so-called unintended consequences, so to speak. So to the extent that that's an opportunity to continue to follow, I appreciate it. Removing the term limits in lieu of damages, at first blush, don't know if, for example, that sort of opens up potential exposure and liability beyond what the limits may be. Secondly, Well, I've stated previously the concerns with the offset and the ability to not do that. Understanding, of course, that will be an increase in exposure and a corresponding increase in policies. I provided by email an example. Rhode Island was held as a state that does what is being proposed in the bill as an offset, and just comparing the UM rates in Rhode Island versus Vermont. The average rate in Vermont is $26.07, and the average UM rate in Rhode Island is 68.04, 160% change. So this is something that, and in Rhode Island, those limits are lower than Vermont. They are currently at 2550, and Vermont's at 5100. So this again would allow policies to be stacked and increase that exposure. The third provision on MedPay subrogation, Senator Sheen, we continue to have the same questions. Unsure really what this proposal does. Subrogation is used all the time. MedPay is available for the insured that has it. It's an optional coverage, and it's the insured can quickly cut a check for medical costs that the insured either doesn't want to access healthcare policies or take advantage of what's there in the policy. It is then, the subrogation would then perhaps ask the at-fault party or insurer to repay basically what's been paid by the insurance company. Again, that is a common practice. Not sure what's unique about MedPay, but it's certainly puzzling to us what's being proposed. And one practical impact or consequence may be that insureds are, not reluctant, but may hesitate to issue those MedPay checks, not expecting the ability to be reimbursed through subrogation in the at-fault parties. And lastly, while we haven't focused on it much, the effective date is a real problem for insurers. It contemplates July 1 of this year. We have no idea when this bill may be signed by the governor. It's almost impossible for insurers to recalibrate their pricing systems, forms, et cetera, by July 1. I would ask you if you consider pushing that out to July of 2025, or at least some period of additional time to allow for systems and structures to accommodate the new pricing structures that will have to be put into place.
Senator Norris.
Quick question, Jamie. Is the MedPay something that people who are covered on insurance pay for?
It's an optional coverage. You can.
Okay, so if they have that optional coverage, you just made the statement that insurance companies may be hesitant about paying those payments, but if they pay for that coverage, then why would they hesitate on it?
They do get the coverage. They get the coverage up to the limits of what they have in the policy. It may be from the at-fault driver, it may be from your own policy, but they get that coverage.
I guess I was confused with the hesitancy that you had mentioned there.
Right now, they know there's the opportunity, at least when there is an at-fault driver, to be able to be repaid for what is issued under the MedPay coverage. With this proposal, you can't do that.
I think my issue with this is, at least from what I'm understanding, is, if somebody gets this MedPay and then later on they get a settlement, why would the insurance company then want to claw back that, $5,000 from the person who received the $5,000 from their insurance company in the first place? So I guess that's just a general comment. So I'm not sure. Yeah, that's my comment.
I mean, I don't know if you want a response to the comment, but
again, if you'd like,
in very simple terms, perhaps say the medical damage is $3,500 and doesn't exceed what's under the $5,000. But I forgot where I'm going from. So you're in essence sort of not having double payment for the same expense.
well, I mean, isn't the settlement to actually, no, I'll just leave it there. But yeah, thank you.
Yeah. Thanks for the chance to come back and visit with you.
Yeah, thank you. Senator Sears, do you want us to hear from Chris Maley or go to committee discussion? Senator Sears, did you want us to go to committee discussion or give Chris?
Yeah, I was just looking for my insurance policy to see if I have med pay. I want to understand that because I think I do. And I don't know how much it costs me.
Is this just an example, or is this Senator Sears'
I
progressive?
think that's an example.
He's got med pay here, 10K per person.
Yeah, I think that was an example that was provided to us earlier.
Okay.
I don't think we have Senator Sears.
Yeah, I don't have my policy. Well, I can't find the. Oh, there it is. I guess I don't have med pay. Maybe because I'm on Medicare. Anyhow, yeah, we can go to committee discussion. It would be helpful, I guess, and see where people are at with the changes. And
Seems okay to me.
Senator North, any thoughts?
I was taken aback there when we talked, early started talking about subrogation, whatever else. I was kind of caught off guard with that. And I realized everyone has jobs and interests to look out for, whether it's, for the insurance companies or whatever else. But right now, I don't have a problem with these changes to 150.
Sounds good. Well, I agree with that sentiment. Senator Sears?
no, I obviously don't have a problem with it. The funny being in the legislature, sometimes you learn things that you didn't know before. And I had no idea this med pay coverage, and then the insurance company claws it back or takes it back from you, and which lessens your total recovery from the injury that was not your fault. And I also, we do hear that this will increase rates, but I'm not sure. The industry itself must be doing quite well. You can't turn on your television without getting an ad for one of the auto insurers.
Yeah, so I do have one question, Senator Sears. Jamie had mentioned that this basically isn't doable using the July 1, 2024.
Yeah. I think December, either, I don't know which is better, December 31st or January 1st, but we should probably give them more time than that. I think that's a good suggestion.
Yeah, I would December 31st at the end of this year, but either the 31st or the 1st of January will be amenable.
Probably January 1st.
A compromise between July 1 and
January would be better.
January 1 would be, Jamie likes January 1. I'm willing to go along with that one.
Yeah, I'm fine with that. I think it would be hard for them to redo policies, assuming the governor signed it in May and didn't, then you've only got 30 days.
Sounds good.
Maria, do you have that change?
Yes, I do.
So January 1, 2025 for section 3 effective date.
Yep.
Any further discussion from you folks? Senator Sears, I don't think we have anything else in the room. You want to
Let's
take 5 and then go to 195?
I was thinking we could vote right now.
Sounds good.
You want to contact, Senator Bruce?
Yeah.
Just run down to his office.
I can pop into his office.
I hope everybody had a good town meeting week and a restful time.
I did. I know
I did
Senator
too.
Moe did. She was
I
out
know
of
we're
state.
live, but just reminding us we're live.
That was good. Caught up with a lot of house projects that needed doing. So.
That's good. How did your moderator duties go, Senator Norris?
They went quite well. I thought it was gonna be a short meeting, like an hour. It turned out to be a little over 2 hours, but it was fine. I haven't been doing it as long as many folks have in Vermont, but this was my 12th year as moderator, so.
Well, I think Bobby Starr's like 50 years.
Oh my God, yeah, we had breakfast the other morning. He's been here for a while.
Yeah. I guess we're looking for a motion to report favorably S-150 as amended.
So moved.
Senator Sheem has moved that we report favorably S-150 as amended in draft 1.1, which will be probably 1.2 or 2.1 with a change in effective date of from July 1 to January 1 of 2025. Ben, is there any discussion? Hearing none. Ben, do you want to call the roll, please?
Yep. So, Senator Bruce,
Yes.
Senator Norris,
Yes.
Senator Bohowski,
Yes.
Senator Sheen,
Yes.
and Senator Sears.
Yes.
All right.
I can report the bill if Maria has it ready for tomorrow morning.
No problem.
Or later this afternoon, whichever.
Okay, I'll get you a final copy this afternoon.
Great. Thank you. Senator, is Jay Green available yet, or is he?
They will be testifying via Zoom today, and they are in the newsroom.
Okay. This is the bail issues.
Would the committee like their folders on?
Yes, please. Trade you.
I believe you.
Yeah, I've got mine. Thanks.
Thank you.
We're working on 2.1?
I think so. Yeah.
Good morning, members of the committee, Chair Sears. For the record, Jay Green, I use they, them pronouns. I'm the policy and research analyst for the State of Vermont Office of Racial Equity. Here to provide comments on specifically, mostly on the electronic monitoring section of, I'm reading off of draft 2.1 of S195. It's dated February 28, 1:22 p.m. Is that the copy that the committee has as well?
Yes.
Great, thank you. Excellent. Okay, thank you. So I will aim to provide a written version of these comments to the committee by the end of the day today or tomorrow at the latest. But I wanted to make a couple of points about the concerns our office has with the expansion of electronic monitoring. First of all, I would note that the Department of Corrections does have a limited electronic monitoring program in place already for home detention. I think it would be appropriate for the committee to hear from the Department of Corrections on the successes or challenges that that program has already faced. I think our office would further suggest that there should be a joint fiscal note on this proposed expansion of electronic monitoring if there hasn't been already. Has there been a joint fiscal note requested on?
There were reports from several years ago on the Windham County, and there were documents that suggested that it was actually saving money over incarceration. And that report, I can't remember the date that report available, and our expectation was that we would reestablish a program similar to the Windham County Sheriff's program, and it would provide the problem with the current. I believe we did hear from the Department of Corrections, and the concern with the current home detention program from many quarters was that it is passive and not active all the time. So a person who's being monitored could be anywhere, and you wouldn't know that until the next business day.
Okay, thank you very much for filling in those gaps, Chair Sears. To prepare for this testimony, I read a very detailed.
If I could fill in one more gap, Jay, I missed,
Mhm.
and that was the assumption has to be that these individuals would otherwise be incarcerated. It doesn't work if you use it for people that wouldn't otherwise be incarcerated.
Chair Sears, when you say incarcerated, do you mean that they would be incarcerated awaiting trial?
Yes.
Okay,
Yeah,
I just wanted to clarify that.
The crime is such a nature that, for example, many of the cases in the Windham County project were domestic violence related, and these individuals would have been incarcerated for the protection of the victim or alleged victim. And this offered an opportunity for the person to not be incarcerated, continue to hold their job, et cetera, et cetera.
Okay, thank you. That is a helpful clarification because I think one of the concerns that I was planning to raise was the concern over how electronic monitoring in some jurisdictions is used very expansively for not every crime, but for many minor violations or crimes that people might be accused of, and that the more expansive programs tend to overly surveil and be applied to defendants of color, especially Black and Hispanic or Latino defendants. So we would want to monitor any Vermont expansions of electronic monitoring for any racial disparities in how they're being applied. For this testimony, I reviewed a really excellent report from the Vera Institute for Justice called People for Electronic Monitoring, or People on Electronic Monitoring. And they had a very helpful policy recommendation section at the end of the report about recommendations for jurisdictions that are planning to implement electronic monitoring, and what would sort of the recommendations be to prevent racial disparities and make sure that these policies don't lead to additional harsher sentencing for people who are subject to electronic monitoring. Because what the literature review that the Vera Institute did found is that people who are on electronic monitoring 24/7, they tend to get caught violating their conditions of release more than people who are not on electronic monitoring, but specifically, they tend to get caught violating the conditions of the electronic monitoring itself. And one of the ways that that can occur is that if there's a power outage, if there's an interruption of GPS service to the electronic monitoring devices themselves, people can sometimes be reincarcerated because of technical failures of the devices themselves. So given that, Vermont has pretty, how do I say this? Vermont struggles with maintaining consistent access to power, electric, and cell phone service throughout our state. I just over the weekend, I live near a downtown village center, and I lost power because of the winter storms this weekend. So this is, if the committee decides to implement electronic monitoring on a larger scale, we would definitely want to watch for any issues that arise with the electronic monitoring devices themselves. And we wouldn't want, the Vera Institute's suggestion was that any violations related to the devices not being charged, the devices possibly malfunctioning, disconnection from GPS service, that those do not get treated as a reason to increase someone's incarcerative sentence. So that might be a conversation that we could have with the Department of Corrections about. I'm not sure if that would be encoded in statute or encoded in DOC policy, but we would encourage the committee to ensure that violations related to a malfunction of the electronic monitoring device do not put people back in incarceration or in an institutional setting.
Jay, if I could chime in real quick, I totally hear your point about the GPS issues, the power issues, and I think that in looking at page 16 in the policies section with DOC being required to establish written policies and procedures, I think that is where those nuances would be shaped out, and and I think that it would ultimately have to go to a hearing where if somebody violates their conditions and burglarizes a home and they say, well, my GPS or my monitor malfunctioned while I was out during these hours, versus somebody who has a genuine malfunction, I think both of those types of scenarios would have to present the facts of their situation, the context of their situation, in order to determine whether or not there was a malfunction or if there was a GPS issue or a power outage or something along those lines. But your point is well taken.
Thank you. Thank you, Senator Hashem. The other, another policy concern that the Vera Institute report raised was that on the topic of cost savings, oftentimes the cost savings that jurisdictions experience when they implement electronic monitoring are because they are passing on the cost of electronic monitoring to the people being monitored themselves. That is, it may be a cost savings to the state government if the state government is not paying for the service fees and device fees associated with electronic monitoring. But that would be very concerning because we would be imposing additional cost burden on people who are convicted or not convicted of who are still pre-trial in some cases.
Yeah, I don't think the intent has been. I know that the Wyndham project didn't, and I don't think our intent here is to have the individual pay for it. It is, you actually raise an issue that's somewhat problematic for some people with the interlock system for DUI. where they have to pay, I think it's $100 a month or whatever. I don't know what I don't know what the cost is. I shouldn't mention that, but the individual pays for the interlock system to provide so they can start their vehicle.
Thank you. That is a very important point. To quote from the Vera Institute's report, they basically they explored how there have been numerous class action lawsuits against electronic monitoring vendors for charging exorbitant monitoring enrollment fees, and in some cases amounting to over $900 per month. So that is, in a state where we have a $200 limit on cash bail, I would find it very concerning that, if any electronic monitoring companies were allowed to charge significant fees for this is all hypothetical. If they were implemented.
Right, as Senator Baruth and I both on the Appropriations Committee a couple of years ago, or maybe it was as soon as last year, I don't remember, we dropped the charges to the individuals for domestic violence treatment, which had been in effect for years, and it caused many problems, and we're having much more success when the state covers the cost of the treatment. We did that with justice reinvestment, by the way.
Thank you for that.
Jay, before you keep going, Senator Bohovsky also has a question.
Yeah, I did have a question, Jay. Thanks for being here. So I don't know, I haven't read all of the Vera report you're referencing. And in terms of cost savings, I know that in Vermont it's incredibly expensive to incarcerate someone. So was there any analysis of the cost savings not from a standpoint of passing on the cost of monitoring to a defendant, because I agree we should not do that, but just in not having people in the carceral setting?
I am struggling to remember the exact contents of the report.
Okay.
And whether that was addressed. The portion of the report that I copied and pasted into my note sheet was about the overarching concerns with relying on private companies to do the electronic monitoring itself, especially I believe in this version of the bill in draft 2.1. Yes, there's still language in here that says shall provide 24 hours a day, 7 days a week electronic monitoring with supervision and immediate response. So that is going to require some significant cost investment on the part of the state to run a 24/7 immediately responsive monitoring program. And I think a joint fiscal office note might be helpful in determining whether that would be comparable, what the cost would be of incarceration versus electronic monitoring, if the state government is expected to take on the costs of paying for this 24/7 service and not passing on the costs to the people on electronic monitoring.
Thank you.
Thank you. Another point that the Vera Institute report made that I wanted to highlight for the committee was that any statutes related to electronic monitoring, it would be very helpful to have a limitation on the use of smartphone-based apps or any technologies that rely on biometric data. Biometric meaning, fingerprint. Sorry, I'm having trouble with words today. Biometric data, meaning the kind of data that tech companies tend to collect that identifies a person using their biological characteristics, like their fingerprints, retinal scans. There are more expansive definitions of biometric data in statute, but the reason that is concerning is for the person's privacy, because there are very few regulations on the federal level on what big tech companies can do with biometric data once it's been collected. Vermont is taking steps to enhance the protection of consumers' biometric data. There's a bill in the House, H121, that is looking at enhancing protection of Vermonters' biometric data for the purposes of data collection and such. So, again, this is one way that electronic monitoring statutes could be significantly improved, is by preventing the use of smartphone related apps to do the electronic monitoring itself, because they are largely unregulated by the federal government and could be invading people's privacy by collecting their data in unregulated ways. And just to be clear, our office has serious concerns about the potential for these electronic monitoring programs to be implemented in ways that tend to overly surveil and monitor people of color disproportionately compared to white people in Vermont. But since I wanted to give some options for the committee to consider in ways to ameliorate some of the racial equity concerns, if the committee is committed to moving forward with creating this electronic monitoring program.
Jay, real quick, we just have Senator Baruch has a question.
Absolutely.
Thank you for the testimony. I'm just wondering, I've always understood that incarceration itself was disproportionate to non-white Vermonters. And so I'm wondering, I understand you're raising concerns about the electronic monitoring program being disproportionately used for Black and brown Vermonters. But it seems to me that is the other option, is that we incarcerate those folks or detain them. So I think in all situations we're striving for proportionate response, equal response. But it seems to me that the concerns you're raising could be directed at the carceral system in general. So it's hard for me to feel as though the electronic monitoring program is worse in that way, or is it worse than the disproportionate effect that we would see in standard incarceration?
I thank you for that question. I think that you are correct that our concerns broadly apply to the carceral system in general. I would note that as electronic monitoring is introduced in various jurisdictions around the country, it tends to sweep more and more people into the state surveillance systems. People who might not have otherwise been incarcerated at all might be placed under home electronic monitoring. And I would be.
Yeah, he did condition this on that these people would otherwise be incarcerated.
Great. That is an excellent way to rein in the possibility of the electronic monitoring population really increasing. And the Vera Institute report was also wanted to note that the reliance on private corporations to run electronic monitoring may be one reason that the population of people who are on electronic monitoring tends to increase after electronic monitoring programs are created in states, because there have been cases where judges receive kickbacks for referring people to electronic monitoring from for-profit electronic monitoring companies. So, there's I think the committee is proceeding with the best of intentions, but I think there have been some demonstrated pitfalls to electronic monitoring that need to be watched for very carefully if this program goes into effect. And one of those would be watching that we don't see racial disparities in who is being sentenced to electronic monitoring pretrial, and being careful about who is put in charge of electronic monitoring. Is it a for-profit company that has a profit motive to have more people in their electronic monitoring system? Is who is paying for the electronic monitoring, the devices themselves? Are there provisions in the policy for people who don't have home internet service or can't afford home internet service, that kind of thing?
Thank you.
Thank you. The other policy recommendation that the Vera Institute report made that I wanted to highlight for the committee was that that any time served on home detention or electronic monitoring should be applied to a future sentence if the person is ultimately sentenced to incarceration. If they're already serving time on I believe that may already be part of, I'm not sure if that is part of standard practice in Vermont of applying retrial incarcerated time served to the post-trial sentence. I apologize that that is not my
I believe we'll
area of
have
expertise.
Ledge Counsel check on it, but I believe that if you're in the home detention program currently, you're receiving credit for time served. If
Thank
you
you.
are found guilty.
I'm just making a note of that. Thank you, Chair Sears. Thank you for hearing the testimony today, and I just wanted to again restate that it would be highly concerning if electronic monitoring became sort of a to use the Vera Institute's reports, whereas a tripwire back into immigration detention, jail, or prison is, to quote from their report, it would be very concerning if people were reincarcerated or were sent to an incarcerative facility because of technical violations of electronic monitoring, either a device malfunction or the kind of violations that are, maybe they stayed out 30 minutes past their curfew and they should have been in their home, but they were 30 minutes late to getting home. That kind of violation is not necessarily a new criminal act in and of itself, but we may end up increasing the penalties on people who are in an electronic monitoring program if that kind of technical violation becomes a punitive tool. So our office has reservations about the use of electronic monitoring. I think that there are ways to address some of these concerns that the committee is discussing, but there are ways that the statute could be strengthened somewhat to further protect people who are part of the electronic monitoring system from overly punitive policies, from paying for the costs of their own monitoring, and from having their data collected and used by the largely unregulated tech industries that create smartphone apps and other electronic monitoring technologies.
Senator Morris.
Good morning, Jay. So when you do submit your written testimony, could you highlight this report that you've been referring to so we could find that, or I can find that online? I appreciate that.
Absolutely. Thank you.
Thank you.
Senator Bohosky.
I have a question, and it may not be for you, Jay. It may be a broader question that we don't know the answer to, but what are we using? Because we have a small electronic monitoring program now. What are we using to run that? Who is running that? What's the tech? I'd love to just get a little bit of information about what we're doing right now. And I don't know if you have that information. I recognize that's not your policy area of expertise. But it did bring up to me that we are doing this. How are we doing it?
Well, the history is that if I could help, we started the home detention program years ago, and electronic monitoring is passive, and so it's run by Department of Corrections, and I don't know who provides the monitors and where they obtain them, but there's only last I knew, there was about 10 people statewide on electronic monitoring. And the Department of Corrections came in with a proposal, I believe, to appropriations or Joint Justice Oversight to discontinue the use of the passive monitoring, because it's only, you only know when probation and parole comes on duty on Monday morning, for example, what happened over the weekend, and the person was not available. And then a little later on in our discussions of the bail reform, the whole idea was that the Corrections and Institutions Committee in the House was going to take on the detention issue. And then all of a sudden, it got involved here when Sheriff Anderson came in and talked about the program in Windham County years ago, and the success they had and how he'd like to replicate it. And so that's where the discussion came. And then we put language in that suggested that the department could contract with, my intent, and it came from Senator Ash actually years ago when we were doing the home detention program, was why not get Massachusetts to do our, pay them to monitor, because it doesn't have to be in Vermont. You can monitor from anywhere. And they have extensive monitoring. So anyway, we put language in the bill that we're currently considering regarding the idea that it could be outside contracted. But I think Sheriff Anderson, I'm sure he did, I know he did, he indicated a more than willingness to try to replicate that program that Sheriff Clark had in Windham County years ago.
Thank you. That was helpful.
Yeah, thank you.
I believe that you'd find that most of the cases that Sheriff Clark had were domestic violence.
And were those active monitoring or passive monitoring, like we do?
They were active. They were active. Because what they did was they worked with the victim, the state's attorney, and the alleged perpetrator, and they all had to kind of agree that they would do that. And that's so I would say the majority were domestic violence related, serious domestic violence related cases.
If I could make a suggestion regarding the bill language, I'm looking at page 15 of 26 is where the electronic monitoring program section starts, section 5. I would encourage the committee to remove the ability of the department to contract with a for-profit entity to provide electronic monitoring services. That's the very last line, line 21. So strike a for-profit. Because of the concerns highlighted in the about the potential for corruption and lack of transparency about funding, and about expenses or fees being passed on to the consumer by for-profit companies, and just for-profit companies creating a sort of perverse incentive to put more people on electronic monitoring than necessary for the purpose of profit making. So on page 16 under policies, subsection D at the bottom, so page 16, line 16, policies. The Department of Corrections shall establish a written policies and procedures manual for electronic monitoring. There is an electronic monitoring policy available on the Department of Corrections website. So that may be slightly redundant. Maybe shall update their policies or something to that effect might be more appropriate, just because there is a or if the committee is proposing creating a new program, then perhaps it is correct to say to keep that language as is. But I just wanted to highlight that the DOC does have a publicly available policy on electronic monitoring. That's 430.12 is the policy number, and I'll include that link in my written testimony. Just checking this. I believe that was the basically the summary of testimony that I wanted to provide on behalf of the office today. I'm just scrolling through the bill really quickly here to make sure I didn't forget anything. I think our office is still concerned with the bill language on page 24, the conduct constituting the offense of using a firearm shall be considered a violent act for the purposes of determining bail. I think that our I think that this kind of sentencing enhancement is concerning because it enables it is highly reminiscent of many historical policies that resulted in mass incarceration and specifically mass incarceration of Black and Latino people in the United States by selectively enforcing and drug laws in a biased way, and then charging people of color with increased, more punitive sentences. So, our office just wanted to, we wanted to continue to flag that. That was page 24, subsection D, as in Delta, lines 4 through 6.
We're aware
Yeah.
of that concern, but as I've stated many times before, and I think other members of the committee have been clear, that the uptick in firearm violence and the use of firearms is very concerning to the public as well, and to all of us. I think that's the genesis of this effort to try to. I think, when I started this effort last year with S4 and started to try to deal with some of these issues, and made me less popular in some areas, but I will say that I have seen a decrease in the use of firearms in Bennington since S4 passed. And the police and other law enforcement agencies seem to have been able to curtail some of that. But the use of firearms is pervasive in the state right now. It's something that, we always dealt with, that people carried firearms and we don't have certain laws, etc. But the fact is that the use of them is up, and that's the reason for that language. People start shooting or brandishing and intimidating with firearms. There needs to be something. We need to deal with that, in my opinion.
Thank you, Chair Sears. That is understood. I also wanted to point out that I think there are other opportunities to interrupt firearm violence that rely on more community-based responses that address the root causes of violence, and that our office would be more in favor of those sort of community-based root cause approaches to addressing firearms violence rather than relying on increased criminalization of firearms. So that is generally our position on that.
Understood.
Thank you. Thank you very much for the opportunity to testify today.
You're welcome.
I believe that is where my comments end. If the committee has any other questions.
Well, please hang in there. We'll continue the markup today and at a future time on the bill. Or actually not today, but I forgot when it's scheduled, Ben. It's on our agenda for this week.
Tomorrow.
Tomorrow. So,
Senator Sears, just a quick
Yep.
note since we're briefly talking about tomorrow. Do we also want to try tying in S-196 and getting some clarification on that along with S-196? Okay, thank you.
yes. So we're scheduled to take up, is Ben available?
Yes.
I'm here.
All right. We were going to hear from the Attorney General's office first. Is that correct? Ben, did you?
The Attorney General's office is present. Did you want to have them go through the bill first, or?
Well, if you can briefly go through the bill and then give the Attorney General an opportunity, or Attorney General's office an opportunity to weigh in. We cut her off in the middle of her testimony, and I was reminded of that this weekend. So we apologize to the Attorney General.
Well, I'm happy to do a brief walkthrough of the amendment and then hand it over to the Attorney General's office. So for the record, my name is Ben Novogrodski from the Office of Legislative Counsel. Before the committee is amendment, strike all amendment draft 1.1 of S-285. And for reminder, S-285 is a law enforcement interrogation bill that would create prohibitions on deception during the custodial interrogation of juveniles under the age of 20. What this amendment does is it strikes a large part of the bill and just creates a mandate to develop a model interrogation policy that would come from the Vermont Criminal Justice Council. And then once that is developed, a requirement that each law enforcement agency adopt, enforce, and follow the model interrogation policy. And if it is not, there can be grant funding withheld as an enforcement mechanism. So I can go into the details of the policy itself right now. So in section 1, it requires the Criminal Justice Council on or before October 1st of this year, in consultation with the Attorney General, to collaborate and create a model interrogation policy that applies to all persons subject to various forms of interrogation, including custodial interrogations occurring in a place of detention, custodial interrogations occurring outside a place of detention, interrogations that are not considered custodial regardless of location, and the interrogation of individuals with developmental, intellectual, and psychiatric disabilities, substance use disorder, and low literacy levels. On or before January 1st of next year, the council, in consultation with stakeholders, including AHS, Vermont League of Cities and Towns, the Human Rights Commission, and the Judiciary and the Innocence Project, shall update its model interrogation policy to establish one policy for law enforcement agencies to adopt and constables to adopt, follow, and enforce as part of their own interrogation policy. So that's the model development or the development of the model policy. Section 2 would go into effect in 2025 and adds a new subdivision B that on and after April 1st, 2025, a law enforcement agency shall be prohibited from receiving grants or other forms of financial assistance if the agency is not in compliance with the requirement to adopt, follow, or enforce the model interrogation policy established by the council pursuant to section 2371 of this title. You might be asking, what is section 2371? Well, on the next page, section 3 creates 2371, which is the statewide mandate for the policy. It cross-references custodial interrogation, place of detention as they currently exist in Title 13. Subsection B mirrors the model language policy that we went over in section 1. And then subsection C creates a policy adoption deadline of April 1st, 2025 for each law enforcement agency and constable exercising law enforcement officer and trained accordingly shall adopt, follow, and enforce the policy. Subdivision 2 creates a bi-yearly update to the policy if necessary. So basically it empowers the Criminal Justice Council, in addition to the Attorney General, AHS, and the Human Rights Commission, to review and if necessary update the policy. Subsection D creates a April 15th, 2025 deadline for the Criminal Justice Council to review the policies of the various law enforcement agencies for compliance with the model policy. If it's not compliant, it empowers them to work with the law enforcement agencies, and if all else fails and there's still a lack of compliance, the model policy adopted by the Criminal Justice Council will become the policy of the law enforcement agency or constable. Turning on to page 5, subsection E creates a requirement that the council incorporates the provisions of the section into the training it provides law enforcement officers. Subsection F requires law enforcement agencies to report to the council annually on whether an agency or constable has adopted the interrogation policy. The council is empowered to determine the currentness of officer training related to that. And then subsection G creates an annual reporting requirement to the Judiciary committees in the Senate and the House on those officers and constables that have received interrogation training.
Mr. Chair, if I might.
Yep.
Ben, so I think it's very clear. Am I correct that it no longer in any way directs what the policy should be? It just says they have to have a policy addressing the 4 areas: in place of detention, outside, not considered custodial, and then developmental, intellectual, and psychiatric disabilities. So this seems, and I understand that we've moved from mandating that they not use deception, but it seems like, unless I'm wrong, they could develop a policy that doesn't in any way limit deception and just have that be the policy that would satisfy all the requirements of this.
That's correct.
Seems counterintuitive given where we started.
Yeah. No, I agree. You know, what we heard from the witnesses was that they needed a policy before we banned that practice. So I think it makes sense to me to sort of explicitly say, like, develop the alternative policy so we can ban the practice.
Right. Yeah, it seems to me this asks for a model policy without saying what the model would be, right? So a model policy, you give direction and you say, like, we want to get rid of all bullying and harassment in high schools. And so that's the intent. And then you develop a model policy, have the school boards do this independently. If they don't, there's some kind of stick.
Right.
But here we haven't laid out what the model would look like. We just said that there should be a model.
Yeah, that's accurate.
Well, and I think when it was paired with the language of, like, we're banning this and develop a model policy, it was much clearer that that was
Right.
the direction we were headed. Whereas now that we're doing just the model policy, I think it's pretty important that we sort of explicitly state the direction that we're moving.
Yeah.
Okay, I think we should add deception or something in there. We need to, is a good point.
Well, couldn't we,
Particularly,
Senator Sears, couldn't we at least, I mean, all these folks who sit on this council are now law enforcement officers. They're well-educated individuals. We've got quite a nucleus of individuals sitting on this council. The part that disturbs me, I guess, is I don't have a problem with them coming up with the policy or whatever else, but there's no check back as far as sending it back to us, make it that simple to say, okay, this is what we recommend, and give us the opportunity to review this policy that they come up with and then take it from there, would be my suggestion.
Well, I think if we put together Senator Mahovsky's suggestion and yours, that makes sense to me. We would give them some general direction and then have a check back to see what they produce.
I think that's probably the wisest course, and we want to particularly emphasize juvenile deception. We were told early on last year, before the bill got vetoed, that the Vermont State Police don't use deception, and they don't use. I forgot the name of that interrogation. Yes, thank you. Yeah, that they don't use that. So you may that only a couple of agencies use it in the state. So we want to keep. I think our intent would be that they have model policies that aren't that.
Yes.
I don't know how to word that properly. That's why Ben gets the job.
Senator Bohosky also has a question.
Yeah, the other thing that I know was in S6 around this policy development, and Senator Sears being on appropriations, you can probably shed some light. It was a policy position for the Criminal Justice Council. They had testified last year that they have a bit of a lack of resources in terms of developing policy. And so I'm wondering if that should go back in this bill.
Well, I kind of left it out because we already got about 17 million in requests for criminal justice issues beyond the governor's recommend.
Yeah, I just want to make sure that they're well-staffed to do what we're asking them to do in the.
I had a conversation with Representative Squirrel. He said he was at 17 million. In requests, not requests. Some of the agencies can't make requests, but in dollars above the governor's recommend in the criminal justice realm.
So I got a question, Ben. I'm sorry, you haven't even got to that part yet. Effective dates. Are you done with the presentation?
Yeah.
Oh, effective dates. The action take effect on July 1, 2024. Does that mean this you have to have the policy done by?
No, so it would just be section 1 that goes into effect, which is the development.
Okay.
And then the grant eligibility and the actual code of the statewide policy and the adoption and compliance, all of that goes into effect on April 1st of next year.
So you know, October 1, 2024 to develop the policy.
Yep.
And then I'm not sure where we left it. They're going to send it back to those committees of jurisdiction.
Yeah, I think that's
Under discussion, but yeah, that makes sense to me.
Yeah,
If we're here.
What's that?
If we're here.
So the guidance that I would request.
Well, somebody will be here.
Is, so things that I've heard is adding a definition of deception to be incorporated into the policy, potentially adding that it include or prohibit people that are under 20 years of age from being, because that was.
No,
Well,
I don't
so
think
that-
we should be that prescriptive. I think we should ask for policies regarding deception, particularly, and regarding juveniles. And then let them, I think if we put an age in there, we're going to run into the same darn problem again.
Senator Bohosky?
Given the testimony we've heard and the fact that we're looking at model policy, I would really like to see us add language that says that they need to move towards the elimination of deceptive interrogation practices, and that's what this policy is for, without a focus. I don't think the police should be lying to anyone, not just juveniles. And it was a compromise for me to come down to a lower age when it was an actual ban. But when we're talking about model policy and looking into it, I think it should be for everyone.
And actually what we're asking them to do is discuss and create policy around the topic of deception. So they're going to come back with something, and it may be that they can agree on banning deception for everybody. So I agree. I don't think we should limit the discussion to juveniles, although we could make it clear that it has to include juveniles as a separate component, maybe.
Yeah, and including juveniles. Something. Ben will
Perhaps
come
like
up with some excellent
considerations
wording.
for juveniles under a specific age, or do you want to set an age or just say juveniles?
I wonder if we could we hear from the Attorney General? Maybe she has some ideas.
Yes, good morning.
Good morning,
Dana.
Yes. Would you like me to start answering specific questions or go off
Any
of
comments you have?
Okay.
Unfortunately, we got about 10 minutes left, so.
I will breeze through. My name is Dana DeSano. I'm an assistant attorney general in the criminal division of the Attorney General's office, and much of what I had planned to testify to today is no longer applicable given the draft that was filed today. I'm mindful of the committee's time, and I do appreciate the opportunity to come back. For those of you who had to leave before I testified last time, briefly, I've been a prosecutor for nearly 14 years, and during much of that time, I've worked with special investigative units, and I currently work with the Internet Crimes Against Children Task Force, which is housed at the Attorney General's office. The Attorney General's office shares this committee's commitment to providing extra protections to juveniles to prevent convictions predicated on false confessions. We also share this committee's commitment to protecting juveniles who are victims or potential victims of sexual violence. And we appreciate the work that you've all put into furthering those objectives thus far. I was here last time with ICAT Commander Matt Raymond and Mojo, and started to testify about specific concerns we had with the earlier draft, not so much from a policy maker perspective, but from a practitioner's perspective. And we appreciate you having considered the feedback that has been given thus far and giving us the opportunity to collaborate and find a workable solution. In reviewing the current strike-through draft filed today, as I said, much of what I plan to elaborate on is no longer applicable, but as an overview, our current position is that our office is supportive of the policy consideration and generally supportive of this moving forward, but has two recommendations. Senator Sears touched upon this, but in keeping with the spirit of the original bill, we would recommend having this apply to juveniles. ICAT Commander Matt Raymond supports this recommendation as well. From a practitioner's perspective, model policies to a certain extent already exist through the case law that is clear and robust. And we do have some concerns about competing with that case law and creating confusion. But we do, however, understand wanting to provide additional protections for juveniles beyond those that already exist in Vermont. And therefore, we would support this moving forward with the scope focusing on juveniles. Our second recommendation is sending this through the Law Enforcement Advisory Board before it goes to the Criminal Justice Council. And the concern here is bypassing a group of experienced practitioners on the Law Enforcement Advisory Board who may be in the best position to develop an initial draft informed by their on-the-ground, in-the-field perspectives, and then sending it to a wider group, including our important community partners and stakeholders on the Criminal Justice Council for additional review and scrutiny. As you know, the Law Enforcement Advisory Board by statute is tasked with undertaking formal review of law enforcement policies and practices. So we think that their inclusion makes sense here. I understand that we've taken a similar approach with body-worn camera policies and domestic violence policies, and that has worked well and is perhaps a more efficient approach. If the committee is not inclined to start with the Law Enforcement Advisory Board, we would alternatively respectfully suggest that the Law Enforcement Advisory Board be specifically included somewhere in the process of developing the model policy. Our concern, like last time, is having a well-intentioned policy with perhaps some unintended consequences that may undermine our ability to protect crime victims. And so we think that having the practitioners involved in these discussions as much as possible is important. And to that end, following up on some of the comments made a few minutes ago, if you're looking for language regarding deception, we do think that the Illinois statute is close to what may be a workable solution for stakeholders, or at least a good starting point for those discussions. That has been brought up before, and I'm happy to send that language to the committee if that would be helpful.
It'd be helpful if you could send it to Ben and
yes,
we can incorporate.
Senator Gohosky, do you still have a question?
I do still have a question. I was trying to see if I could answer it myself, but my understanding is the LEAB has a member on the Criminal Justice Council. So they are at the table.
Yes, and I think our concern is there's so many nuances and scenarios that may not be readily apparent to people who aren't in the field and practicing this. And so we think that it's important that we have a larger group of the law enforcement community coming to the table and sharing different experiences that can better inform the policy. We certainly think that the Criminal Justice Council members will have valuable feedback and scrutiny, but we also want to make sure that there's a breadth of law enforcement experience at the table when these policies are developed.
I appreciate that. And so given that the LEAB actually has a seat at the Criminal Justice Council, one of the things I am looking at when I look at section 1, subsection 4B, where it lists stakeholders, I wonder if adding the International Police Training Council to the list of stakeholders would help alleviate some of that concern. It feels weird to me to have the LEAB do it and then bring it back to someone who has, like the LEAB having sort of double representation feels strange to me. But I do think adding the International Police Training Council might be a really helpful stakeholder in that discussion.
Yeah, and I'm not familiar with the International Police Chiefs Association, but I will just note that very few countries have a common law system like ours with court-made, so to speak, law where that even exists. So I can see where coming from other countries, looking at our statutes, they may find them to be insufficient because they don't have similar protections in their own countries. So we do have those additional protections through our case law here. I think that that's worth noting when considering out of country perspectives on what's going on with our cases.
Just a quick comment. I agree with having the LEAB also be involved here. I think that to your point of the fact that the LEAB is comprised of folks or police officers with breadth of experience is important for the conversation. I mean, a detective's experience is different than a road officer's experience compared to a supervisor, a chief of police, or a lieutenant of a barracks. I don't personally know the exact consistency or experiences on the LEAB, but as was described, I imagine there's a variety of perspectives on there. And given that they've seen other policies before going elsewhere, like the body cams that you had described, I think it makes sense. So thank you for the recommendation.
Thank you.
Yeah, and if I might add to that, even though the LEAB has representative on the council, so does the Vermont Sheriff's Association, so does the Troops Association, they all have members on the council. However, said that, they can't speak for the association on their own without bringing these associations involved, so they can go back to the council and say, okay, this is our stance on this. So bringing the law enforcement advisory board along, many other entities involved as we can, I think is promising for the correct policy involvement.
We will take this up again when we mark up the bill at the end of the week. And I thank Dana.
My only remaining question is just if there's an idea about when those check-ins should happen in the development of the policy, if there is any idea there.
Is that something we can send to the Justice Oversight Committee in the interim when we're not in session, Senator Sears?
Yeah, we can do that. Involves Ben, so yeah.
Yeah, there you go. You're welcome.
So right now it has, October.
Get more work for you by asking that question, Ben.
Be careful what you ask about, right?
Yeah.
So October 1st is when sort of the initial policy is created, and then it says subsection B by January 1st, they adopt one cohesive policy. The check-in somewhere between those timeframes.
There's the chair of the committee, so Justice.
I mean, it could be November 15th.
I'd say December 1st. December 1st would be the normal check-in, and then we could do it at a December meeting of Justice Oversight.
Okay. Sounds good.
Comments you have when we get a later draft ready would be appreciated.
Thank you.
Thank you. And thank you all for putting up with me remote. And as usual, Senator Hashim has got us right on time, and so.
Almost.
He's running a little late here, okay?
Oh, well.
All
right. Thank you all. We'll see you all in a couple hours.